So I'm going to start by looking at what is the distinction between a primary obligation and a secondary obligation in any contract. That's a wider topic than covering this one, but it has a relevance for this topic, which I will explain. I will then look at what a penalty clause is and why the law regards it as objectionable to the extent, although the parties have agreed the clause, the courts won't give effect to it. I will then look at two different eras, if you like, one from the early part of the 20th century, when a test for establishing what a penalty clause is and what it isn't was established, and that operated for almost 100 years. And then in the last 10 years, the Supreme Court has looked again at this subject and redefined the test. The test isn't radically different, but the wording is different, and I think it's intended to have different impact in different situations, but not universally. So to illustrate that, I'll be showing you some cases as to how the courts, since the redefinition by the Supreme Court, have interpreted the new test and put it into effect. I'll also be looking throughout at some practical aspects of this subject, because, as I say, it is important in practice in the realm of commercial contracts. So what is a penalty clause? In summary, it's a provision, the aim of which is to influence or compel a party to perform the contract or not to act in breach of the contract. So it's if you like, it's a compelling measure. It's a measure compelling a party to perform, because it knows if it doesn't perform, it'll be forced to pay money. It can be wider than just money, but usually will be money by way of compensation. But sometimes, and this arises out of the negotiating power between the parties when the contract is being negotiated, sometimes the agreement to pay in certain circumstances can be directed too strongly towards one party's interest to the detriment of the others, and that's where it could become a penalty clause, because the prejudice caused to the contract breaker in having to pay that amount, which has been agreed, but maybe under a lot of commercial pressure in the negotiation, would be out of kilter to the protection it offers to the party who has suffered from a breach of contract. In short, the contract breaker would have been unduly penalised, and it's there that the law steps in to say we need to have a way of assessing what will be unduly in the term unduly penalised, and the onus is on the party who claims it's unduly penalised, if it has to pay this amount, to show it was. If it does so successfully, then the court will not enforce that. It counts as a penalty clause.